युनियन ऑफ इंडिया काय बरं, इंदिरा गांधी है ना, तिथपर्यंत आलो होतो आपण, बरोबर आहे का? आय थिंक तिथपर्यंत आलो की नाही, बरोबर ना? सगळ्यांना आठवत नाही का तरी? तेच पाहिजे ते तुम्ही तुमच्यापैकी काय नाही, तुम्ही तुमच्या बॅचमधून नाही केलेले. त्या मीच्या बॅचमधून माझ्याकडे गव्हर्नर बद्दलचे आर्टिकल्स आले, मी मला तुमच्या बॅचमधून थोडी पाठवले नाही मला, तुम्हाला मी सांगितलं पण नव्हतं नाही. सो नेक्स्ट lecture will have next lecture will have discussion on governor through those newspaper articles, and I'll also let you know what फार वेगळं काही नाही जे मी शिकवतो तुम्हाला इकडे आहे ना नोट्स मध्ये, तेच आर्टिकल मध्ये आजकाल छापलं जाते. आता कसं की न्यूजपेपर मध्ये येते तर आपण त्याचं एकदा जस्ट विल हॅव जस्ट लुक ॲट इट, राईट? Some Supreme Court lawyers have, I think, wrote article, PDT आचार्यांचं एक आर्टिकल, दुष्यंत दवेंचं एक आर्टिकल, ती आर्टिकल्स मला समोर माहिती आहेत, ते आपण डिस्कस करूया. मला वाटत नाही की त्यातनं काही फार वेगळं असं काही मिळेल, एका 2-3 पॉईंट्स करू शकतो फक्त ते बघू. पण ऑलमोस्ट थिंग्स विच आर रिटन इन द आर्टिकल्स इन न्यूजपेपर, आय थिंक जर तुम्ही वाचत असेल तर तुम्हाला कळत असेल की आपल्या नोट्समध्ये ऑलरेडी आहे, फक्त ते तुम्हाला व्यवस्थित फिल्टर करता यायला पाहिजे. आणि त्या आर्टिकल्सवर बेस्ड क्वेश्चन्स येतात बेसिक मेन्स, जर तुम्ही मेन्सचे क्वेश्चन बघितले. हां तेच म्हणून मी ते सांगतो की आपण आर्टिकल्स आहेत माझ्याकडे आले तर ते आपण डिस्कस करू. ते घेईन मी, त्यात हेच आहे ऍक्च्युली फक्त, कारण काय न्यूजपेपरमध्ये आल्याच्या वेगळ्या प्रकारे मला ते सांगावं, हाऊ टू ड्राफ्ट नोट्स आणि वगैरे ते होईल. जर शक्य झालं तर पण मंडे ट्यूजडे पैकी कोणतं तरी एखादं लेक्चर मिळेल आपल्याला, त्यावेळेला करूया, त्यावेळेला ते करू. मला वाटतं की तुमचं जॉग्राफीचं बहुतेक नेक्स्ट वीक संपत आहे, बरोबर की नाही? हो नाही मग मराठी मीडियमचा नोट्स जॉग्राफीचा हा एक मुद्दा तुमच्या डिस्कशनमध्ये होता. आपण त्या नोट्स प्रिंटिंगला देऊन फार दिवस झाले unfortunately, not to be shared with you, but then I have no other explanation to give, being a person responsible for all those activities administration. We have given notes for printing a month ago, but the printer, so he lost his son few weeks ago. He was 25 and suffered a heart attack in printing press itself, so that was a shock for them, and so we, like, everything was standstill. Half of the notes were ready, now they are completely ready, but then probably tomorrow or day after tomorrow I think that we'll have those notes here, like ends. Once we get them, we will immediately distribute, right? फक्त जॉग्राफीचे नोट्स. आणखी काही छोटे छोटे कंपोनेंट्स आहेत आपल्या सिलेबसमध्ये ज्याच्या नोट्स तुमच्याकडे नाही, दे आर स्टील अंडर प्रोसेस, म्हणजे त्याच्या बनवायचा अजून चाललेलं. बट बाय द टाइम यू कम अक्रॉस दॅट पर्टिक्युलर पार्ट ऑफ टीचिंग, आय थिंक तयार असतं पण मिळतील तुम्हाला जॉग्राफीच्या नोट्स तशा. आणि अदरवाईज मला वाटतं की तुमच्या पोर्टलवर अपलोडेड आहेत त्याच्यासाठी, नाही का? आहेत ना? चलिए फिर आगे चलते हैं, आर्टिकल 83 और उसकी बात करेंगे, है ना? There is a possibility that some of you may find it to be really very far at greater depth than what probably UPSC requires. I don't think so. We are not at all going at the depth. हम लोग कुछ नहीं डेप्थ दिला, हम लोग बहुत सुपरफिशियल इन चीजों को, बहुत ज्यादा सुपरफिशियल. जितना मैं पढ़ा रहा हूँ आपको वो 1% भी नहीं है जितना पढ़ना चाहिए एक्चुअली, अगर किसी को मुझे समझाना है कॉन्स्टिट्यूशन. लेकिन क्योंकि वो ऑब्जेक्टिव नहीं है ना, तो एग्जाम की प्रिपरेशन करें, मुझे लगता है कि इतना कम से कम आपको मालूम होना चाहिए. सो आप याद रखिए इस चीज. चलिए आगे चलते हैं. सो वी वर डिस्कसिंग अबाउट heads of the state. We talked about this case law, if you remember. याद आ रहा है आपको? It is principle of collective responsibility and responsibility towards lower house. That is basically, this is nothing but democratic principles. Democratic principle that is invoked by the group. In similar way, शमशेर सिंह में भी सुप्रीम कोर्ट ने डेमोक्रेटिक प्रिंसिपल के ऊपर ये बताया कि आपके जो प्रेसिडेंट है वो यूएस प्रेसिडेंट से रिजेंबल नहीं करते. If you look at the inaugural address of Dr. Ambedkar in Constituent Assembly on 4th of November 1948, it says that the President of India is not similar to the President of the United States of America. Generally, he is supposed to follow the advice given by Council of Ministers. Generally, not in every case. Dr. Ambedkar also avoids mentioning the fact that he is compelled to follow the advice of Council of Ministers. But he further says that he is supposed to act according to the advice and not contrary to the advice given by the Council of Ministers. But that doesn't mean that he doesn't imagine the possibilities of advice being given incorrectly. Right? But he is trying to make it sure that your office of president remains very much within the constitutional scheme. The constitutional scheme aims at creating democratic government and not particularly parliamentary democracy and not presidential democracy. So he consciously makes it clear in very first paragraph when he answers the question, what type of government this constitution is going to establish. In very first paragraph, he says that it is definitely not going to be presidential system or presidential form of a democracy, but essentially going to be parliamentary form of democracy, right? So that he makes very clear. So in this principle also, in this case also, or otherwise, in some setting, we'll find that this idea of collective responsibility is core idea, and depending upon or from the point of view of this idea of collective responsibility, one needs to interpret different provisions of the constitution. But then that is again not enough to explain in completeness what are the provisions pertaining to executives under Indian constitution. Article 83, as you can see here, limits the duration of this body to 5 years. Which body? Council of Ministers, right? And Lok Sabha. So basically Lok Sabha, right? Your constitution doesn't prescribe any tenure specifically for ministers. है ना? Right? Tenure ministers के लिए कोई tenure नहीं, right? But then that body as a whole, that is what is lower house of the parliament, definitely has got a fixed tenure of 5 years. It can be dissolved earlier, it can continue later on also, after 5 years, depending upon the circumstances, right? But 83 says that there is limit of 5 years, right? Unless dissolved earlier. Read together, it implies that the Council of Ministers has maximum tenure of 5 years. Maximum, right? So it implies, it is not directly given in the Constitution. If you remember in last lecture I said that for prelims, the tenure of the Council of Ministers is not given in the Constitution, right? But for mains, you can definitely talk about possible implications of those provisions of the Constitution and can say that ministers generally may, at the max, continue to remain in the office for 5 years, as that is the maximum time period for which one government or one particular parliament, sorry, not parliament, Lok Sabha can continue. Right. So ministers must resign on losing vote of confidence. It is an established convention. I don't know whether we discussed this in last lecture or not. I think we have already talked about this, right? It is an established convention and not constitutional provision, right? If Council of Ministers refuse to vacate the office after such laws, the President may dismiss it. The discretion to dismiss the government is a limited one. In keeping with British parliamentary conventions, it is invoked only in rare circumstances when the minority government stubbornly imposes itself against majority in the House, right? So policy differences, for example, are not valid grounds on the basis of which dismissal should take place of otherwise stable government. The government which is otherwise stable, right, should not be dismissed only on the grounds of policy or policy differences. Doing so will likely to invite, constitutional uncertainties or anxieties of many kinds. I think I have explained to you in last lecture what do you mean by this. Because if the President of India or even governor of any state, uses this particular basis or ground to target the Council of Ministers, those who enjoy absolute majority or majority on the floor, then that would create a type of a vacuum in the assembly. Dealing with that would be really very difficult or probably to a certain extent impossible for a governor or president of India. The reason being, if the established government is dismissed because there are certain policy differences between governor and the chief minister or probably his council. The chief minister and his council is basically a party which is enjoying or holding command over majority number of MLAs sitting in the house. Now if they are dismissed, then in that case governor is definitely going to face a problem of appointing new ministry. And that is very difficult to deal with. But then, as of course, maybe from same party, new chief minister and council of ministers can be appointed. I just think that this possibility also needs to be explored. There is no harm in it. Because we don't elect chief ministers, we don't elect prime ministers, we elect parties, and parties select the prime minister and chief minister. So parties in that way should enjoy that power. If governor has rejected some council on some valid basis, and a chief minister and council on some valid basis, in that case, the party should exercise an opportunity, to appoint new chief minister and council, right? Select new chief minister and council to which government will formally appoint. Right? I'm just thinking that there is possibility. Otherwise, then this established mechanism is unidirectional and creates problems, which we have recently faced, and we have faced some of those problems in the past, that is during Madam's time. So that is what is mentioned here. We are looking at this provision from the point of view that finding alternative prime minister will prove difficult. New appointee is unlikely to command majority in the lower house. Last time हमने बात की थी इसके ऊपर, आता था तुम्हारा? So the ensuing instability will be executive legislative paralysis with the government unable to enact policies into law. काय कळते का? हे तुम्ही वाचून वगैरे येता ना रे, निर्णय येताना. माझ्या लेक्चरला तरी कृपया तुम्ही वाचून येत राहा. नाहीतर दुसरा पर्याय काय ना की I'll tone down the lectures, bring it down to the level where you can easily understand it and can read it in learning. I can do that with no difficulty. So we can वो तो लक्ष्मीकांत 7 दिन में खत्म हो जाएगा हमारा. 7 दिन की रोज 2 घंटे का एक लेक्चर लक्ष्मीकांत में पढ़ाने जसं कुछ आहे. हे जे नोट्स तुमच्याकडे पोर्टलला शेअर केलेले आहेत, प्रिंट करा, लेक्चरला याच्या आधी वाचा एकदा आणि मग These are articles written, by great scholars, those who enjoy a great deal of authority and command over subject as of now in India. They have great reputation abroad also. इनके बियॉन्ड अब इन चीजों के ऊपर अभी के टाइम में लिखने वाला कोई नहीं, तो मैं ये समझ सकता हूँ कि आपको समझने के लिए डिफिकल्टी बिल्कुल होनी ही है। इसलिए आप पढ़ो 2 घंटा या फिर 4 घंटा जो हम लोग यहाँ पे बैठ के प्रवचन सुनते हैं उसको मैक्सिमम यूज करो। Yes, so there will be an instability, as I said, because if the governor dismisses the majority government, then that would result into executive legislative paralysis. Executive है नहीं, executive अगर नहीं है तो legislature में कौन lead करेगा? है ना? Your prime minister and council, as a head of a particular party commanding majority in the parliament or majority in the lower house, puts the business in the house. Yes, everyone, right? So lower house particularly, carries on the business that is brought to the table by the executives. Executives, I have already said you, if you all remember, executives would conceive the idea, would be delivered by the house. So जब executive ही नहीं है, तो house क्या करेगा? It is different story that every single member sitting in the house can actually initiate new proposal, but then that would be chaotic. You need a direction to the nation state. You have to have fixed people, those who would be looking or taking care of maybe administrative aspects, and accordingly, whatever policy changes that they need in the form of law, they will bring it in the legislature. So if you don't have the prime minister or maybe chief minister at state level and their councils, respective councils, right, that actually paralyzes being more particular both the legislatures, because otherwise also legislatures initiating proposals on their own and making it through, and then finally governor signing the bills, passed. Because see, an individual member of the legislature can also initiate the proposal. So passing bill is not a big deal. वो बहुत बड़ी बात नहीं है, वो तो पास हो ही सकता है। समझ लीजिए कि ट्रिपल तलाक वाला बिल पास करना, वो पास हो सकता है, इसमें कोई ज्यादा बहुत दिक्कत नहीं आएगी। बजट कौन पास करेगा अगर आपके पास कोई एक गवर्नमेंट नाम का कोई एक फॉर्मल स्ट्रक्चर नहीं है? अच्छा, बजट किसके नाम पे पास होगा? बजट भी वैसे अदरवाइज भी कौन पास करता है? पार्लियामेंट पास करता है। तैयार कौन करता है बजट? एग्जीक्यूटिव, राइट? You don't have executive, so there is definitely going to be a paralysis. Who would lead then? If the governor or president in such circumstance finds no other option but to dissolve the parliament, the legislature itself, right? That would result into new elections. Until new elections, the dissolved council of ministers, those who lost the confidence on the floor, would be continuing. Everybody, or those who lost the pleasure of the president, will continue. But that also doesn't make a sense. The reason being, why would you dissolve Lok Sabha or legislative assemblies when you know that there is one party which commands the majority? मेजोरिटी में कोई पार्टी है ही ना। इशू क्या है? इशू ये है कि जो काउंसिल ऑफ मिनिस्टर, प्राइम मिनिस्टर या फिर काउंसिल ऑफ मिनिस्टर चीफ मिनिस्टर है ना, उनका और गवर्नर का या फिर उनका और प्रेसिडेंट का नहीं, उनमें शायद दे आर अगेंस्ट ईच अदर बिकॉज ऑफ पॉलिसी डिफरेंसेस, बिकॉज ऑफ आइडियोलॉजिकल डिफरेंसेस, एज यू कैन सी इन केस ऑफ गवर्नर ऑफ केरला। There are rarely, I don't think there are policy differences. The policies brought in by Kerala government and passed through the legislative assembly, I'm telling you, would be far more closer to constitutional ideals than what central government is doing. What's the matter then? Why the Kerala government every now and then finds himself in the news? What was the case with Maharashtra prior to this government coming into force or coming into power? It was quite apparent that the differences were definitely not related to any constitutional provisions. Those differences more were based on political differences or ideological differences. And such political and ideological differences should not create constitutional uncertainties. Everybody, right? So apart from governments, the president may also dismiss individual ministers. Ordinarily, it is for prime minister to recommend such dismissal. Kerala के गवर्नर ने dismissal की बात की थी ना किसी एक मिनिस्टर की, right? Whether a president may dismiss an individual minister at his discretion remains an open question. We talked about it in last stage. Similar rules apply to the state executive. Similar rules apply to state executive, right? So the governor of Kerala is in not position to dismiss an individual minister, saying that you doesn't enjoy my pleasure. Though your constitution says that president, the governor of India, governor of a state, under Article 146, enjoys discretion, and his or her discretion, the scope of his or her discretionary powers to be decided by the governor itself or governor himself or herself within his or her discretion. So scope भी वो खुद ही decide करेंगे. उसमें court will not interpret what is going to be the discretion of governor. It is to be decided by governor itself. तब तो ये absolute power के जैसे हो गया ना, मतलब मेरा discretion मैं खुद ही decide करूँगा क्या discretion हो, right? Say that said, you still need to accept or follow the norm and convention that is established at center, and it says that governors, president, generally speaking, should not be using pleasure rule against an individual minister. That should be ordinarily done on the advice of prime minister. हम तो बोल रहे हैं ऐसे, लेकिन सच में ऐसा है क्या? इसकी possibilities हमें check करनी चाहिए. So I'm not saying that governor of Kerala cannot use pleasure rule. Governor of Kerala can, for that matter, every governor can. can use pleasure rule, right? We cannot deny that fact, right? We just need to understand or check what probable or possible issues to be considered by governor while using pleasure rule. ये सोचने जैसी बात हो सकती है. अदरवाइज गवर्नर प्लेजर रूल यूज नहीं करेंगे जब तक सीएम नहीं बोलेंगे, क्योंकि वो गवर्नर का काउंसिल नहीं है ना, वो सीएम का काउंसिल है. So governor should not directly interact that way with an individual minister, because he didn't appoint him directly on his will or wish. He appointed him or her as a minister after the choice made by CM. So he must be speaking with the CM, not with an individual minister. So the Kerala governor definitely had, an option to speak with the CM and accordingly change the minister instead of creating an issue. If he thought that the minister doesn't enjoy his pleasure, he should have informed the chief minister first and must have asked chief minister to act. Must have given him a reasonable time and must have given a time to concerned minister to explain his stand if the governor thought that something was wrong, right? This is how it should be. But then, of course, it became an issue. Governor said that I will use my pleasure rule. Chief minister and council should have said that go ahead and use. Should have said him that go ahead and use your pleasure rule. Let's see what are constitutional issues, right? Will you be in a position? वो governor को पूछना चाहिए था उसी वक्त question. Will you be in a position to deal with uncertainties that would result after you using pleasure rule, right? That would result into what? That would result into dismissal of council. So dismissal of or dissolution of state legislative assembly, and thereby resulting into election. So election is basically an expenditure. So probably governor's ego and governor not acting through the set rule or maybe set way of under constitution, right, resulted into we all ultimately end up spending a lot of money on conducting election to the assembly, which was just a year ago or maybe year and a half ago was elected and elected into majority. It is not hung parliament or this. So how can governor then compromise, the mandate given by the people just because he thinks that or she thinks that the council doesn't enjoy the pleasure? करते हैं तुम्हारा? मैं आपको दोनों साइड से बता रहा हूँ. ये नहीं बोल रहा हूँ कि प्लेजर रूल गवर्नर यूज नहीं कर सकते. करेंगे कैसे, कब, क्यों, इसके ऊपर सोचना चाहिए हम. अभी तक इंडिया में इस तरह की सिचुएशंस एटलीस्ट सेंट्रल लेवल पे नहीं हुए. स्टेट लेवल पे हुए, काफी बार मिसयूज किया गया प्लेजर रूल का, जैसे अभी हम लोग केरला के गवर्नर के कॉन्टेक्स्ट में इस चीज को देख रहे हैं. और इसलिए अगर आप आर्टिकल्स देखोगे ना, न्यूज़पेपर में आए हुए आर्टिकल्स, तो क्या बोले, वन ऑफ द आर्टिकल्स सेड दैट गवर्नर इज अंडर कॉन्स्टिट्यूशन नॉट अबाउट इट, राइट? आई थिंक दैट वाज रिटन बाय दुष्यंत दवे. That article was written by Dushyan Dave. I think it was Dushyan Dave. He used to be the former president of Bar Council of India. Right? So the articles are really nice. आप देखो एक बार PDD आचार्य जो है उनका भी आर्टिकल देखो. So what I'm telling is there are possibilities. We are not saying that governor has intentionally been made puppet. Right? Governor is a responsible position that needs to be used responsibly. Position को responsibly use करना चाहिए. So we are saying that similar rule applies to the state executive, but with one notable exception. Government with a stable majority may be dismissed under 356 if the president is satisfied that the situation has arisen in which the government of the state cannot be run according to constitutional provisions. So 356 says this, but the 356 is an extreme situation. It is not ordinary circumstance wherein you are taking a step to dismiss the government. You cannot. 356 basically says that if president is satisfied that government and state cannot be run according to constitutional provision, and only in that case can 356 be imposed. So what do you mean by not being run at 365 भी होना चाहिए? Right. So basically, what do you mean by not being run according to constitutional provision? ये जो है ना, यहाँ पे 365 होना चाहिए. 356 says that if the president is satisfied on the report of the governor or otherwise that the constitutional machinery in state has failed, right? Then he can replace that constitutional machinery at state with constitutional machinery at center. I mean to say, like, president may make an arrangement for legislative business to be carried on behalf of state by somebody. Let me make it simple. What is constitutional machinery at state to look after the governance? State assembly. Constitutional machinery at state? CM and council of ministers. वो मशीनरी है स्टेट पे. कॉन्स्टिट्यूशनल मशीनरी और कुछ है वो मशीनरी में एक्स्ट्रा? हाँ, गवर्नर सीएम एंड काउंसिल ऑफ मिनिस्टर्स. लेजिस्लेटिव असेंबली नहीं है ना. क्यों नहीं लेजिस्लेटिव असेंबली? बिकॉज उसका होना अदरवाइज भी यूजलेस है. अगर हमारे पास सीएम काउंसिल नहीं है और गवर्नर नहीं है तो असेंबली का क्या करेंगे? तो कॉन्स्टिट्यूशनल मशीनरी एट द स्टेट लेवल इज बेसिकली अ मशीनरी टू गिव एन एडवाइस टू काउंसिल टू गिव एन एडवाइस टू गवर्नर. हु रन्स द गवर्नमेंट एट स्टेट? हु इज executive head of the state? Executive head of the state, it is governor. So for governor, you have CM and his council to give an advice. That is constitutional machinery created at the state level. If the president is satisfied that the constitutional machinery at the state has failed, what does that mean? That means that you don't have CM and his council. That means you don't have any party commanding majority in the assembly. Correct? Everybody. If president is satisfied, either on the advice of or either on the report of the governor or otherwise, governor लिख के भेज देंगे love letter. यार तुमचीच वाट बघत होतो, तुम्ही लवकर काय करा, presidential rule impose करा म्हणजे. कळलं? कधी? Only then when you don't have any party commanding majority. Then in such a situation your governor basically is helpless. He doesn't have his council. He does not have his council, and so may ask center to impose presidency. बरोबर? वन कंडीशन. सेकेंड, ये वाला लाइन 365 में भी दिया हुआ है. It says what president is satisfied with the situation either on the report of the governor or otherwise. The situation has arisen in which the government of state or government in that state cannot be carried on according to constitutional principles. Now to understand this, I just list down few articles here. But there are other articles also which can be referred to. So you have article 256, you have 257, 256 and 257 are the articles which can be used. Are the articles which can be used to come to this conclusion. So I said that there is 256 and 257. Specifically, there are other articles also. If the state government disrespect the verdicts given by or orders given by the Supreme Court, that may be considered as a situation wherein state government in state cannot be run according to constitutional principles. The reason being every Supreme Court order and decree and judgment is to be followed by each and every legislative as well as executive authority across India. That is constitutional article. So state अगर उसको disrespect करेगा मतलब state government constitution के हिसाब से नहीं चला सकते. ऐसा ही meaning हुआ उसका. 256 has general obligation. General obligation. So it says that the executive power of the state shall be so exercised not to prejudice the legislative power of the parliament in that state and executive power of the center in that state. Executive power of the center is extended to ensure that the state governments follow the laws passed by the parliament. है ना? ये मैं आपको बाद में समझाऊंगा. हम लोग जब फेडरलिज्म को देखेंगे ना तो ये आर्टिकल्स में डिटेल आपको बताऊंगा कि उसका क्या मीनिंग होता है और क्यों ऐसा. लेकिन ये आर्टिकल्स यहाँ पे लिस्ट क्यों कर रहा हूँ मैं? इसलिए क्योंकि आपको ये समझना चाहिए ये क्या लिखा हुआ है. Situation has arisen in which government of state cannot be run or cannot be carried on according to constitution. Constitution ने ये बोला कि स्टेट गवर्नमेंट अपना एग्जीक्यूटिव पावर यूज करते वक्त हमेशा इस बात को याद रखे कि कोई पार्लियामेंटरी लॉ जो वो स्टेट में एप्लीकेबल है, पार्लियामेंट्री लॉ तो अक्रॉस इंडिया एप्लीकेबल है, वो स्टेट में जो एप्लीकेबल है उस लॉ के अगेंस्ट कोई एग्जीक्यूटिव उस लॉ के अगेंस्ट आपका कोई एक एग्जीक्यूटिव एक्शन ना हो. अगर ऐसा है तो फिर उस केस में बात ये हुई कि आप पार्लियामेंट के लेजिस्लेटिव अथॉरिटी को डिसरिस्पेक्ट कर रहे हो. ऐसे केस में वो स्टेट गवर्नमेंट को कॉन्स्टिट्यूशनल लेजिटिमेसी नहीं है कि वो कंटिन्यू कर पाए. और अगर प्रेसिडेंट को ये लगता है ऑन द बेसिस ऑफ फैक्ट्स कि हाँ भाई स्टेट गवर्नमेंट बिल्कुल पार्लियामेंट्री लॉज को डिसरिस्पेक्ट कर रहा है, गवर्नमेंट स्टेट लेजिस्लेचर नहीं, गवर्नमेंट मतलब एग्जीक्यूटिव डिसरिस्पेक्ट कर रहा है, तो उस केस में प्रेसिडेंट कैन इंपोज प्रेसिडेंट रूल ऑन स्टेट. एंड दैट imposition of president rule has nothing to do with majority of a party in the house. The majority government can also be dismissed if they are not following the constitutional principles in their execution. clear का everyone? very good. तो आपने शायद इससे पहले कभी ऐसे सुना रहेगा ना हमारा कॉन्स्टिट्यूशन यूनिटरी बायस्ड है ना, जहाँ पे यूनियन गवर्नमेंट के पावर्स ज्यादा है और स्टेट गवर्नमेंट के पावर्स कम है या फिर समथिंग ऑफ दैट सॉर्ट. सुना है आपने? यही एक प्रोविजन है. ऐसे कुछ और प्रोविजन भी है आपके कॉन्स्टिट्यूशन में जहाँ पे आप ये देख सकते हो कि स्टेट के ऊपर कॉन्स्टिट्यूशन ही कुछ लिमिटेशन डालता है. पार्लियामेंटरी लॉ का लिमिटेशन है स्टेट गवर्नमेंट के ऊपर कि तुम किसी भी पार्लियामेंट आज तक जितने भी पास किए हुए लॉज है ना पार्लियामेंट में उसमें से किसी भी लॉ के किसी भी प्रोविजन के अगेंस्ट आप काम नहीं करो, तभी तो रूल ऑफ लॉ रहेगा ना. सिंपल सी बात है, बात समझी? अब कोई स्टेट अगर गलती से या फिर इंटेंशनली किसी पार्लियामेंट्री लॉ को डिसरिस्पेक्ट करे है ना, तो उस केस में क्या होना चाहिए? उस केस में तो प्रेसिडेंट ने बिल्कुल सही से समझना चाहिए कि हाँ भाई स्टेट काम नहीं कर रहा तो उसको रोकना पड़ेगा, क्योंकि रूल ऑफ लॉ की बात है. पता करते का एवरीबॉडी. आपको याद है कुछ समय पहले जब सीएए पास हुआ तो केरला की स्टेट लेजिस्लेटिव असेंबली ने सीएए के अगेंस्ट एक रेजोल्यूशन पास किया. हमने क्यों अवेयर ऑफ दिस? केरला स्टेट लेजिस्लेटिव असेंबली पास द रेजोल्यूशन अगेंस्ट सीएए सेइंग दैट विल नॉट इंप्लीमेंट इट, है ना, राइट? दैट वाज अनकॉन्स्टिट्यूशनल. नो असेंबली ऑफ द स्टेट कैन पास अ रूल और अ रेजोल्यूशन दैट वुड डिसरिस्पेक्ट द लॉज पास्ड बाय द पार्लियामेंट. कॉन्स्टिट्यूशनल स्कीम में आता ही नहीं है, वो अनकॉन्स्टिट्यूशनल. अच्छा, रेजोल्यूशन पास करना सिंबॉलिक था केरला गवर्नमेंट. वो चाहते थे कि हम लोग कलेक्टिवली बताएं सेंटर कि हम लोग यहाँ पे नहीं चाहते ये पर्टिकुलर, आप इसको कंसीडर, इसलिए वो बनाया. लेकिन अगर अभी केरला गवर्नमेंट इंप्लीमेंट करेगा सीएए, करेगा ही, करना ही पड़ेगा. अगर नहीं करे तो इमरजेंसी के लिए उनको फेस करना पड़ेगा. देयर इज अ कॉन्सिक्वेंस ऑफ देम डिनाइंग द कॉन्स्टिट्यूशनल कंपल्शन. देम डिनाइंग द केरला गवर्नमेंट डिनाइंग द परफॉर्मेंस ऑफ कॉन्स्टिट्यूशनल ड्यूटी. दे आर रिस्पांसिबल, दे मस्ट डू इट, इफ नॉट प्रेसिडेंट रूल. कळते का? बऱ्याच वेळा असं वाटतं कळते का विचारल्यावर मला सवय लागली हो म्हणायची. If you lose the context in between, you can raise your hand, ask me to repeat. I will repeat. होता क्या है ना, जब मैं बात करता हूँ मेरे दिमाग में 50 चीजें साइमल्टेनियसली चलती रहती हैं. मैं ये भी बताऊँ आपको, मैं वो भी बताऊँ. आप देखो काफी बार लेक्चर में कोई एक लाइन को लेकर बहुत सारी जगह पे हम लोग घूम के आते हैं, है ना. तो अगर आप कॉन्टेक्स्ट नहीं पकड़ पाओ, उसका लिंक नहीं पकड़ पाओ, तो हाथ ऊपर करो, बोलो कि सर नहीं समझ में आया, आप वापस मैं समझाता हूँ. क्योंकि कुछ चीजें एज्यूम्ड है कि आपको शायद, जैसे केरला के गवर्नमेंट ने पास किया हुआ रेजोल्यूशन, ये मैंने एज्यूम किया कि शायद आपको मालूम है. अपने से कुछ लोगों को हो सकता है मालूम ना, आप बाद में जाके पढ़ सकते हो, है ना. बोला I'll have to check, but one of them, probably not 356. There is difference in language of 356 and 365. Ultimate consequence is same. They are not same. Ultimate consequence of having state emergency is same. 356, yes, 356 basically talks about failure of constitutional machinery, right? And 365 is this. तुम एक क्रॉस चेक करो, हो सकता है मैं शायद उल्टा बोल रहा हूँ, probably मैं उस तरह से बाहर नहीं करता कभी, लेकिन आप देखो एक बार, इसमें से कोई एक, इनका लैंग्वेज अलग है, इसलिए इनका मीनिंग अलग है. 365 के रूप से आप ये नहीं बोल सकते कि मेजोरिटी में नहीं है गवर्नमेंट, वहां पे तो प्रोबेबली मेजोरिटी वाला गवर्नमेंट आप डिस्कस कर सकते हो अगर वो कॉन्स्टिट्यूशन को डिसरेस्पेक्ट करता है, मतलब किसी लॉ को डिसरेस्पेक्ट, वो पॉसिबिलिटी है। तुमने एक बार बोला, जस्ट चेक वंस, मे बी इन द ब्रेक टू लेट मी, है ना, यू कैन नो। He is not a person, he is not a citizen, he is the first place government, and so doesn't enjoy unrestricted or the level of freedom that we enjoy, speech and expression. He or she doesn't enjoy that. He or she cannot take defense under the argument that no, I spoke in my personal capacity. You cannot speak in public place or at public place holding that constitutional position in your personal capacity, right? And that too, it is a constitutional position. So that is simply not possible. Okay, जायचं का पुढे? Recording पण ऐका बरं का, परत घरी जाऊन. The provision has been invoked more than 100 occasions, many of them under questionable circumstances. So problematic circumstances. सब हम लोग बिल्कुल देख सकते हैं कि 356 को भी और 365 को भी काफी हद तक हमने मिसयूज कर चुके हैं हम लोग. हमने we have not respected it. In such instance, governor take over the administration of state until new government is appointed or new elections are held. These two things are different. Until new government is appointed and new elections are held. ना अलग-अलग चीजें. Yes or no? You can dismiss the government and appoint new government from the same assembly. Right? And you can dismiss the government, and so you can also dismiss the assembly and can held new elections and get new government and new assembly. This is the critical difference. Contrary to the practice of state level, Council of Ministers always exists to aid and advise the President. The Constitution doesn't envisage any situation when the President may govern on his own. I don't agree fully with what has been written. I don't think that even at state level, Constitution imagines the possibility of governor governing the state on his own. Constitution says that in such circumstances, it is not governor's rule, it is president's rule, right? And president under 356 or when there is a state emergency has been asked to appoint the body, right, to take care of legislative business of state legislature. So that body can be parliament. So parliament may take over the functions of state legislature and accordingly may guide the execution in the state. Or president will appoint a body which will look after the education in the state, execution of policies in the state, right, under the command of governor. So basically there is no that way your constitution doesn't imagine the possibility of governor taking care of administration on his own. It's not on his own, right? And certainly not at the central level. But as of now, whatever you see here, a critical difference, you can consider that as a difference. I hope I'm clear. कळतंय सगळ्यांना मी काय बोललो ते? आपण काय म्हणतो? लक्ष द्या बरं सगळ्यांनी. मी फक्त यासाठी नाही सांगितलं, मला माहिती तुमच्यातल्या काही लोकांना कळलं नाही, तुम्ही काय बोलला नाही. नाही, मला टाइमचं कंपल्शन. अदरवाइज आई विल जस्ट सेट ऑन वन प्रोविजन एंड आई विल कीप टीचिंग यू फॉर आवर्स टुगेदर. लक्ष द्या. गवर्नर और आपके प्रेसिडेंट, इसमें एक बेसिक डिफरेंस है. क्या डिफरेंस है? तो हमने ये बोला कि 74 says that there shall be council of ministers headed by prime minister to aid and advise president. Correct? 163 और 164 को देखो. यहाँ पे भी प्रोविजन ऐसा ही है. There shall be council of ministers headed by chief minister to aid and advise governor. There shall be. So there is that constitutional compulsion existing in both articles at center and as well as at state, right? But because under 356 or for that matter 365, you can dismiss the government at state. You can dismiss the government at the state. So you can assume or you can consider that there is a vacuum now, and governor is on his own. But practically speaking, governor is not on his own. When there is a vacuum of council of ministers at state, there is nobody to aid and advise to the governor. At that time, you can see that president actually takes over the administration of that state. But president there has a council of ministers to give him an advice. So the state basically is run according to the advice given by council of ministers and prime minister to the president. However, this is what is the possibility. However, the president of India may not choose taking an advice from council of ministers and prime minister and may appoint a separate body under the guidance of the governor, right? And then that body will give an advice to the governor and the administration of state may go on. But now when it comes to legislation or the laws to be passed in that state on state-based subjects, who will do that? So for that also, president under constitution has a power either to make an appointment of a body which will look after the legislative functions or maybe which will take care of legislation for that state, or president may entrust that responsibility to the parliament. Okay, right? So I said that yes, of course there is a difference, but not to that extreme, right? Everyone. The only difference that to a critical difference is without council of ministers and chief minister also, governor will have some other body to take an advice from and run their administration, which is not imagined at this time. आता कळलं का? आधी पण म्हणाल तुम्ही. So Supreme Court arrived at this conclusion in UNR Rao versus Indira Gandhi with the lower house dissolved in December 1970. Indira Gandhi lost her mandate as a prime minister. The appellant argued, उन्होंने बोला कि lower house को dissolve है, क्या इंदिरा गांधी का कोई काम? Without lower house, there was nothing. Council of ministers should be responsible. The minister should resign. right, or be dismissed. Thereafter, the president must carry on the government to the best of his abilities until new ministry is installed. Right? Argument seems to be valid. सही तो लग रहा है. कलेक्टिव रिस्पॉन्सिबिलिटी की बात की ना हमने थोड़ी देर पहले, है ना? कलेक्टिव रिस्पॉन्सिबिलिटी बात हमने बोला कि भाई कलेक्टिव रिस्पॉन्सिबिलिटी की बात है. किसको रिस्पॉन्सिबल रहोगे तुम कलेक्टिवली? काउंसिल ऑफ मिनिस्टर. वही डेमोक्रेटिक प्रिंसिपल है. लोअर हाउस, सॉरी, लोअर हाउस है, वही डेमोक्रेटिक प्रिंसिपल है, राइट? अब लोअर हाउस ही नहीं है, तो अब आपको आप किसको रिस्पॉन्सिबल? बेसिकली आपके होने का ही कोई मतलब नहीं है ना. तो अदरवाइज प्रेसिडेंट है ना, प्रेसिडेंट देख लेंगे गवर्नमेंट एंड बिजनेस ऑफ द गवर्नमेंट होते का. आर्गुमेंट ये है. लेकिन आपको क्वेश्चन ये भी पूछना चाहिए, तो फिर प्रेसिडेंट अगर गवर्नमेंट को देखेंगे तो प्रेसिडेंट किसको आंसरेबल रहेगा? हमें बस ये चाहिए ना कि कोई ना कोई आंसरेबल रहे. हमने गवर्नमेंट को इसलिए डिसमिस किया, हमने बोला कि इंदिरा गांधी या उनका काउंसिल नहीं रहना चाहिए क्योंकि अभी लोअर हाउस ही नहीं है और उसके वो आंसरेबल नहीं रहेंगे, है ना. तो इनके होने का कोई मतलब नहीं. तो प्रेसिडेंट के होने का क्या मतलब है? अगर आप पूरा पावर उनके पास देखो, बोलोगे प्रेसिडेंट रन करें, वो किसको आंसरेबल है? वो भी तो नहीं है किसी को आंसरेबल. तो फिर अभी हमारे पास क्या सोल्यूशन होना चाहिए इस सिचुएशन में? इस सिचुएशन को कोई सोल्यूशन तो निकालना चाहिए ना हमें. चलिए देखते हैं. The court rejected this reading of 74 clause 1 says that there shall be council of ministers with prime minister at the head to aid and advise the president, है ना. there shall be. अब मैं वही सोच रहा था, यूएनआर राव वर्सेस इंदिरा गांधी हम लोग क्या स्टेट को नहीं अप्लाई कर सकते? बताता हूं मैं आपको. चलिए इतना पूरा कंप्लीट करते हैं, फिर मैं बताता हूं स्टेट के केस, है ना. इतना पहले कंप्लीट करते हैं, अदरवाइज आप कंफ्यूज हो. The provision means what? It says there shall be a council of ministers always. There shall always be council of, हमेशा होनी चाहिए council of ministers. प्रोविजन ये बोलता है, ऐसे कोर्ट ने बोला. Even if the lower house is dissolved prematurely, the ministers remain in the office until alternative arrangement is made. सुप्रीम कोर्ट ने बोला आप डिसॉल्व करो ना हाउस को, जो मिनिस्टर्स ऑफिस में रहेंगे until new arrangement, alternative arrangement is made. To hold otherwise and give effect to appellant's contention would change the whole concept of executive. appellant जो बोल रहे हैं, जो इन्होंने यूएनआर राव ने बोला कि नहीं अभी इसका कोई मतलब नहीं होगा, अगर हम लोग वो मान ले तो पूरे एग्जीक्यूटिव के पूरे कंसेप्ट का मीनिंग, कॉन्स्टिट्यूशनल मीनिंग चेंज हो जाएगा. ऐसे सुप्रीम कोर्ट का मानना है. करते का तुम्हाला एवरीबडी मागे लास्ट बेंचेस इकडे काय परिस्थिती आहे कळतंय का? पुढच्या लेक्चर मध्ये ना तुम्ही मागे बसले, तुम्ही इकडे पुढे येऊन बसा 5:30 ते 7:30. सो इन अदर वर्ड्स, है ना, सुप्रीम कोर्ट ने बोला अगर आप ये बोलोगे कि काउंसिल ऑफ मिनिस्टर्स नहीं है, सॉरी पार्लियामेंट लोकसभा नहीं है, तो काउंसिल ऑफ मिनिस्टर्स के होने का कोई मतलब नहीं बनता और गवर्नर ने खुद के सॉरी आपके प्रेसिडेंट ने खुद के हाथ में लेना चाहिए पूरा एडमिनिस्ट्रेशन. ये अगर हम लोग मान ले तो एग्जीक्यूटिव का कॉन्स्टिट्यूशन के अंदर जो कंसेप्ट बना हुआ है ना, उसका मीनिंग चेंज होगा. तो क्या कंसेप्ट है एग्जीक्यूटिव का कॉन्स्टिट्यूशन के अंदर? एग्जीक्यूटिव का कंसेप्ट ये बोलता है कि जिनके पास मेजॉरिटी रहेगी हाउस में, है ना, वो गवर्नमेंट को लीड करेंगे. अब अगर वही नहीं है तो गवर्नमेंट को लीड करने के लिए आपको किसने बोला कि प्रेसिडेंट आएंगे? प्रेसिडेंट तो हमने फॉर्मल, अमेरिका बोले ना फॉर्मल हेड प्रेसिडेंट. पता है क्या? The court reasoned it would mean that the president need not have prime minister and ministers to aid and advise the exercise of his functions. Such possibility is alien to the system of executive set up under constitution. करो का? अगर आपकी बात मान ले हम लोग, तो हम लोग बेसिकली ये मान रहे हैं कि प्रेसिडेंट को काउंसिल ऑफ मिनिस्टर्स की और प्राइम मिनिस्टर के होने की जरूरत नहीं, मतलब उनकी एडवाइस की जरूरत नहीं है. ऐसा तो कॉन्स्टिट्यूशन नहीं बोलता. आपको कॉन्स्टिट्यूशन पहले भी और अमेंडेड फॉर्म में भी 42nd कॉन्स्टिट्यूशन अमेंडमेंट के बाद भी यही बोलता है कि देयर शैल बी काउंसिल ऑफ मिनिस्टर्स हेडेड बाय प्राइम मिनिस्टर टू एड एंड एडवाइस प्रेसिडेंट. Earlier version said that he will act accordingly. Later on 42nd amendment के बाद ये बोला गया कि he shall act accordingly. How in both versions, you know, council of minister और prime minister का होना तो तय ही है ना, मतलब उनका होना ही है वहाँ पे एडवाइस देने के लिए. तो ये आपका आर्गुमेंट नहीं चलेगा. Such possibilities alien to the system of executive set up under Indian constitution. This mandatory requirement of the head of the government means that there shall always be someone to aid and advise the state. Head of the state is head of the constitution basically. ये mandatory है कि होना चाहिए. कळलं का? Everybody. Now I have an argument. यार ये सेंटर में अगर हम लोग बोल रहे हैं कि ये मैंडेटरी है, होना ही चाहिए. आर्टिकल 164 भी तो यही बोलता है, देयर शैल बी काउंसिल ऑफ मिनिस्टर टू एड एंड एडवाइस गवर्नर एक्सेप्ट इन केस वेयर ही यूज्ड टू और ही मे नीड टू यूज डिस्क्रिशन. वो चीजें छोड़ दी जाए तो अदरवाइज तो काउंसिल ऑफ मिनिस्टर का होना तय है इसमें भी, है ना. तो हमारा कॉन्स्टिट्यूशन ऐसा बायसनेस क्यों दिखाता है कि पूरे काउंसिल को डिसॉल्व करके गवर्नर को अकेला छोड़ दिया जाए? प्रेसिडेंट रूल के वक्त काउंसिल ऑफ मिनिस्टर्स होते हैं क्या? नहीं ना. तो व्हाई देन कॉन्स्टिट्यूशन ऐसे क्यों करता है? कॉन्स्टिट्यूशन ऐसे क्यों है? हमारे कॉन्स्टिट्यूशन ऐसे क्यों नहीं है कि डिसॉल्व काउंसिल ऑफ मिनिस्टर्स गवर्नर को एडवाइस देंगे न्यू इलेक्शन होते तक स्टेट लेवल. Last won't be wise enough, won't be constitutional. Very good. Exactly.